On the verdict of Nnamdi Kanu's appeal court, the international community has welcomed the verdict. Unfortunately, or however, the government of Nigeria, through the Minister of Justice, Mr. Malami, has rejected it and working assiduously to truncate the verdict of the appeal court. But before we continue, let us see this. Hi everyone, Massive Media welcomes you to this very afternoon analysis. This is based today on the aftermath interview held by the Attorney General of the Federation and the Minister of Justice, Abubakar Malami. Abubakar Malami reacted to the judgment of the Court of Appeal in Abuja on Thursday, quashing the charges against the leader of indigenous people of Biafra, Nnamdi Kanu, saying that Kanu was only discharged by the court, but not acquitted. He stated that there are other issues predating Kanu's rendition, on the basis of which Kanu jumped bail, which remained valid issues for judicial determination. He further stated that the federal government will continue to pursue determination of rendition issues while considering all available options on the judgment on rendition. The statement read, "The Office of the Attorney General of the Federation and the Minister of Justice has received the news of the decision of the Court of Appeal concerning the trial of Nnamdi Kanu. For the avoidance of doubt, by the verdict of the court, Kanu was only discharged and not acquitted. Consequently, the appropriate legal options before the authorities will be exploited and communicated accordingly to the public. The decision handed down by the Court of Appeal was on a single issue that borders on rendition. Let it be made clear to the general public that other issues that predates rendition on the basis of which Kanu jumped bail remains valid issues for judicial determination. The federal government will consider all available options open to us on the judgment on rendition while pursuing determination of pre-rendition issues." Reacting to the interview granted by Malami or the disclosure of information coming from his office, reacting to this, the human rights lawyer Femi Falana, SAN, said Nigerian government is not competent to continue with the trial of the leader of indigenous people of Biafra, IPOB, Nnamdi Kanu, on treasonable charges. What the government of Buhari and Malami, the Minister of Justice, has to do is to negotiate with Nnamdi Kanu rather than rounding themselves on an untriable charges. The human rights lawyer further advised the government that, I quote, "I know the government is not competent to try him. Fact, government cannot try Nnamdi Kanu. What the government has to do, according to Falana, I quote, what the government should do is to sit down with all aggrieved people in the country and negotiate." Falana continued, "If you are negotiating with terrorists, why can you not sit down with Nnamdi Kanu and others? That is a question. Falana continued on the issue of building a nation, a country like Nigeria. He stated, if Nigerians want to build a country, it must be on a platter of justice and fair play. Everyone must be treated equally. This is a statement of one of Nigerian most senior lawyers, senior advocate of Nigeria, and a defense lawyer as well as a human rights activist. He is the defense lawyer of Omoshore, who was also accused of treasonable felony by government of Muhammadu Buhari and the Minister of Justice Malami Abubakar. The senior advocate of Nigeria, Femi Falana, defended Shore when he was accused of treasonable felony by the same government of Muhammadu Buhari in 2019. Chief Falana stated that after the allegation against Shore with treasonable felony in 2019, after we took the first witness, the government couldn't go on. So the government has been adjourning the case, and this is the problem with political motivated cases. This means that Falana is now informing Nigerians and the world that what the government of Buhari is doing is framing people on treasonable felony. He has done it to Omoshore because of his political leanings. He has done it now to Nnamdi Kanu for his own political and agitation leanings. But one thing is clear, Malami and the government of Buhari should realize that Nigeria is not practicing feudalistic political system of King William I of England, which ended in the 14th century. Malami, as the Chief Justice of the Nigerian Federation, should realize that in any case that is referred back to the Court of Appeal, most often the appellate court will remand the case back to the trial judge if it is satisfied that there is evidence to continue the trial. What the appellate court will do is to send back the case with instructions on how to fix errors that the lower court made. However, if the errors tainted the verdict and the appellate court can order a new trial, but however, where the appellate court finds out that allegations against the defendant is frivolous, politically motivated, no merit, and the aim of the prosecution is to convict the defendant, what the appellate court does after review of the case is to quash or dismiss the case, then acquit the defendant and order his immediate release. And this was what happened in the case of Nnamdi Kanu. But the activities of Malami and in his interview shows that it is their intention to jail Nnamdi Kanu without any evidence. The appeal court has carried out the investigation, read the trial cases, the laws guarding the cases, including the human rights effect of it, and trashed the case, acquitted the defendant, and ordered his immediate release. One will recap the publication of December 17th, 2015, where the Federal High Court orders immediate release of Nnamdi Kanu. In this very judgment, Justice Adeniyi Ademola of the Federal High Court, sitting in Abuja on Thursday, ordered the immediate release of the leader of indigenous people of Biafra and founder of Radio Biafra, Nnamdi Kanu, who has been detained by the State Security Services since October 2015. The feudalistic style of leadership of both Muhammadu Buhari and Abubakar Malami as the Minister of Justice remains one of the reasons why the January coup of 1966 took place. I will make reference to this very particular statement of the declaration of the martial law by one of the coup leaders during military era, clear that there are some people in the country one seek to keep the country divided permanently. Two, there is element of tribalists and nepotists within the country that want the country to remain paralyzed. There are those that have corrupted the society, and there are those that truncate the judgment and make people's life to be difficult. They foster and practice injustice using judicial system to express the tribalism in their vision. It is now clear that the reason why Malami as the Minister of Justice and the President of Nigeria and the Tanko Mohammed, the then Chief of Justice of Nigeria, decided a secret trial of Nnamdi Kanu. In one of the newspapers publication, The Punch, which stated the trial of the leader of indigenous people of Biafra, Nnamdi Kanu, is to be conducted in secret, in line with the new practice direction on terrorism-related cases adopted by the Federal High Court. Who was the Federal High Court judge? It was Judge John Tosho of Benue State, who issued the practice direction, said it was adopted in line with the provisions of Section 254 of the Constitution of Federal Republic of Nigeria of 1999. But it was clear that the government of Nigeria planned this very trial of Nnamdi Kanu on the secret circle. It's now clear that the intention was to carry out the secret trial and put him to prison, that is Nnamdi Kanu. But however, well, with the situation, Malami and the regime of President Muhammadu Buhari found themselves, should have given them a clue note and be thankful to the appellate court for quashing the case or throwing the case away and ordering for immediate acquittal and the release of Nnamdi Kanu. Malami and his government or his department would have been very, very grateful because of the following factors, especially when he said, quote, "The federal government will consider all available options open to us on the judgment on rendition while pursuing determination of pre-rendition issues," unquote. Abubakar Malami should realize that in his tenure as the Minister of Justice with his brother President Muhammadu Buhari, that the following indictments has fallen on his table and their regime. They have the following to contend with: abduction and rendition of Nnamdi Kanu from Kenya to Nigeria is an international issue and not only Nigerian issue, but international case. Now they have to realize that Nigerian Senate passed a bill of about 15 years jail for kidnappers or those helping to pay fees to kidnap others. One, federal government of Nigeria accepted that they kidnapped Nnamdi Kanu from Kenya and renditioned him back to Nigeria. You realize also that Nnamdi Kanu made a case against the government on this note. For instance, I quote, Nnamdi in the suit marked FHC/ABJ/CS/462/2022 is also claiming 50 billion damages and 100 million as the cost of the suit. Again, he argued that he was abducted in Kenya by a Nigerian agent, Nigerian government's agent, brought to Nigeria and kept under unlawful custody. You have to also realize that the criminal law on kidnapping, international criminal law on kidnapping states that the criminal intent element required for kidnapping in many jurisdictions is the specific intent or purpose to commit the criminal act in order to harm or injure the victims or another, confine or hold the victim in secret, receive a ransom, commit a separate offenses, and subject the victim to involuntary servitude. Nigerian Minister of Justice Abubakar Malami should then realize that it has committed a criminal offense in the first instance with the government of President Buhari, one both internally and externally. On the kidnap issue too, the government of President Muhammad Buhari and the Minister of Justice should realize that there was an order from the Human Rights Council with order based on its findings and the report resolution 39/46 of 1984, ordering them to release the kidnapped Nnamdi Kanu, a victim of torture, cruelty, and punishment perpetrated by the Nigerian government. They should realize that this is a crime all on the first rendition and abduction in Kenya back to Nigeria. Two, there are other lingering issues. The second one is the issue of NSAS. Nigerian government has been indicted on their role on NSAS issues, the killings, and has been indicted by the International Criminal Court and approved by the United Nations. You should realize this, that you still have another criminal case under your leadership and under the regime of President Muhammad Buhari. You have all this to confront. There is no doubt that the International Criminal Court prosecutor Karim Khan visited Nigeria and spoke with the Vice President of Nigeria, Professor Yemi Osibanjo, on this very particular indictment. This is under the leadership of Muhammad Buhari and Malami as the Minister of Justice of Nigeria. The third is the issue of human rights violations and abuses committed by the Nigerian forces that we are fighting or are fighting Boko Haram's or insurgents in Nigeria. It is your desire and the desire of your ministry and the government of Buhari to ensure that you envelope others and put them in a cage when the regime has many international criminal cases to confront, and you are clicking to make sure that you continue in your desire to fight Nnamdi Kanu and the Biafra and the Igbos. That is the game. Remedies have been proffered by the learned people, the people who understands what the implications of your activities may be in future, but as a fly that wants to follow the dead into the grave, you would not heed to the advice. Now, Abubakar Malami and the government of Buhari is still bent on pursuing Nnamdi instead of using the advantage created by the appellate court to release him and free themselves and enable themselves time to ease other problems confronting them internationally. You cannot have a regime, the only regime in the history of Nigeria that has accrued 3 international criminal cases. It is unfortunate, and you still want to continue. There is no federal system in the modern democracy. Therefore, you are advised to get yourself out of this very issue, releasing Nnamdi Kanu, free yourself, free the country, and then face the issue of the violations and abuse of human rights and the crime against humanity committed by the Nigerian forces when fighting the insurgents in Nigeria, and also the issue of EndSARS, whereby you killed Nigerian youths unequivocally, and you think it is free, and you think their blood will go without questioning. That is what you have to confront, and not Nnamdi Kanu. Nnamdi Kanu is not pursuing a mission that is not in line with the international laws. Therefore, you are advised to quit the issue of pursuing Nnamdi Kanu and withdraw the statement credited to you in one of the newspapers that Nnamdi Kanu was only discharged and not acquitted. This is what massive media is advising you to do, and rethink on what you do. Anything you do, you are doing it on behalf of the government of Nigeria, on behalf of the people of Nigeria. Your behaviors, your personal behaviors will be attributed, on the other hand, to your activities, personal activities, when the case is turned against you. Therefore, with this advice, we come to the end of this very analysis. For our viewers, for our listeners, for those who are interested in our programs and our broadcast, we ask you also to subscribe, press the bell icon to have all our programs come to you directly. Share globally to your friends. Leave your comment. It will aid us to continue the broadcast. What we need is peace, and peace will only be to those who need peace. With this, we come to the end of this very program. May God bless you all. Thank you very much.